Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-3 CR-1 IR-1 visa, and we're discussing a subsequent application for a U.S. tourist visa, often referred to as a B1, B2 visa. The reason for this video is, especially right now, the backlog of immigration cases is rather more than it usually is. The overall process is not moving as smoothly as we'd otherwise like. Notwithstanding our efforts, we try to make things move along, but it's just not a great situation right now. So setting that aside, a lot of people have asked me, well, what if I go ahead and apply for a tourist visa so we can at least unite in the United States while we're waiting for our immigrant spouse visa, or K-3. For the purposes of this video, K-3 might as well be treated as an immigrant visa because the K-3 itself has a dual intent element, but more importantly, the underlying immigrant visa associated with the K-3 demonstrates immigrant intent very clearly. And the reason immigrant intent is such an issue here is because of there's sort of conflicting intentions associated with a tourist visa as opposed to an immigrant or non-immigrant spouse visa in the form of the K-3. Those intentions being, immigrant visas are for immigrants, people that are intending to live in the United States. A tourist visa is a non-immigrant visa. That person has to demonstrate non-immigrant intent in order to apply for that, and they have to be adjudicated by the consular officer as having non-immigrant intent pursuant to what's called Section 214B of the Immigration and Nationality Act. And under that act, that officer needs to make a determination that that applicant demonstrates sufficiently strong ties to their home country or another country outside the United States, and sufficiently, and this is key, weak ties to the United States. This also occurs under the rubric of what's called the doctrine of consular absolutism, where these consular officers' fact-finding is not really subject to review. So the fact-finding they make in these cases in a tourist visa, it's not subject to any type of appellate review or anything. So, and the reason I bring this up is, again, if you've got an already pending immigrant spouse visa case, or a K-3 as well, supplemental, that's really at odds with the intentions you need to have for a tourist visa. Now, there may be a set of facts where it may work. That's probably why it's a good idea to contact a legal professional if you're looking at this kind of scenario, because maybe there is a situation where a tourist visa application might work out. But mostly the reason for this video is to try to forestall people from throwing away good money because they're going after something that they may not be able to get. Again, if the facts of your situation are such that it may warrant a tourist visa, it may be possible to get one, notwithstanding an immigrant spouse visa. But understand that the intentions associated with those two types of visas are very much at odds.